Ladies and gentlemen, welcome to the webinar. Today's webinar topic is From Soup to Nuts, the private equity sale from the seller's perspective. Today's presenters are attorney Gary Forster and attorney Kathryn Jones. If you'd like a copy of today's presentation, please visit the handout section of the webinar interface and you can download it from there. And now, without further ado, I turn it over to our attorneys, Gary and Kathryn. Take it away, Gary.
Well, today's seminar is something that a lot of business owners contemplate, and that's the sale of their company. In recent years, we've seen a huge uptick of what's known as private equity sales, which is not somebody in the industry buying you out, some large player buying you out, but it's basically private funds of cash that are compiled a lot of times in limited partnerships that are available for the purchase of various businesses in a given industry. And that's in light of the popularity of that and somewhat waning popularity of that now, we've had a lot of interest in this topic, so we've decided to put this seminar together. And I'm going to turn it over to Kathryn to work through the topics and what we'll be covering.
Gary, we're going to go ahead and focus on the slides for now, so I'm going to turn off the camera. Okay. Here's our agenda. There's really, about 7 broad categories of things we're going to focus on today. In the interest of time, we might skip around or gloss over a few slides, but the materials are pretty comprehensive, so feel free to take a look at your leisure, and then if you have any questions or follow-ups, feel free to contact us. Soup to nuts, it's an old phrase. It's beginning to end, and so we're going to walk you through the various stages, beginning with the letter of intent. We'll go through due diligence, the purchase agreement, closing, post-closing, and then we'll have a discussion, open discussion, question-answer session. So here, generally, a sale can take on 2 forms, either an asset or an equity sale. The seminar will focus generally on the equity format as opposed to the asset format, but many of the concepts that we're going to discuss today will apply in the asset sale concept. Just a little...
Yeah, let's do a little background on
the
difference.
Sure. The difference between the two is that in the asset sale, the buyer is just purchasing the stuff inside the box. If you think of the company as a box, they're buying the stuff inside the box. Or with the stock sale, they're buying the box itself and the contents, including both assets and liabilities. So from the buyer's perspective, it's better from a liability standpoint to structure the deal as an asset sale. However, in certain industries, I've noticed in healthcare and some regulated industries, it's more convenient to purchase the stock due to licensing transfer issues and things that are avoided when you do a stock versus an asset sale.
Right. So we are finding with a lot of the private equity deals that although typically the seller's forced to usually do an asset sale, which means basically pulling all of the goods and services out of the box and putting them into a new box owned by the buyer, you can actually just sell the box. So from both a tax perspective and a convenience perspective, selling the box is much nicer. You basically don't find this on smaller sales or private-to-private sales, because what happens is if you buy the box, you actually buy all of the proposed liabilities. So if they had a personal injury claim, or if they had a loan that wasn't recorded, you actually would buy that as part of the box. The larger private equity players aren't as concerned about that. Also, the indemnities are stronger, and a lot of times if there's a problem, there'll be a little side box full of escrow cash that the buyer can apply against your purchase price if something, some kind of liability comes up.
And then just one more point is that for tax purposes, the buyer and seller can make an election to treat the stock sale as an asset sale for tax purposes. And we'll get into this a little bit later on, but that gives the buyer some benefits tax-wise to do it that way. The letter of intent is really the first step in documenting the parties' intentions and the business points. Generally, it's non-binding. Certain provisions are binding or should be, and we list those particular areas that the seller will want a binding commitment. Particularly confidentiality, if there's going to be, and there likely will be a lot of exchanges of proprietary and confidential business information in the process, so they will want the buyer to be bound to confidentiality even if they don't move forward with the acquisition.
And that exclusivity, just to make sure you catch that, that's not a buyer issue. That's a buyer issue, not a seller issue. So the buyer will tie the client up, if the client's the seller, for usually a period of 60 or 90 days in terms of restricting the ability of the seller to either provide due diligence information or enter into any other agreement with any other proposed buyer. Because the buyer that you choose and you sign an LOI with doesn't want to really be spinning their wheels if you're negotiating with 3 other buyers. Now, occasionally, it's such a valuable, or the actual business is in such demand that they'll sign a letter of intent without the exclusivity because they just want to be one of several bidders, in a sense, on the business. But almost always, you'll be required to sign an exclusivity with the buyer.
And the parts that are not binding at this stage are the business terms, and those it's an outline of what's intended, but these are often negotiated as part of the process of getting to a definitive purchase agreement. But the LOI can list the purchase price or an estimate of it. Typically, it's an EBITDA based on preliminary review, and then they will confirm that in later due diligence, that they being the buyer. The payment terms are outlined. Usually there's cash, and I've noticed in the private equity deal there's a lot of upfront cash as opposed to some of the smaller transactions.
Well, they have so much cash.
Right. I mean, that's the business that they're engaged in. And then some additional topics that are in the LOI that are flushed out later in negotiations are earnouts, rollover equity, and certain holdbacks and escrows like Gary was talking about.
Yeah, so a lot of the substance of these deals has to do with how much cash you're going to get up front and how much that client is going to be forced to invest in the buyer's general venture. So we do a lot of healthcare work, for instance, and if we have a healthcare seller, but a lot of times people just want cash, right? And the counterbalance to that is the buyer may want the seller to invest in the buyer, to be part of the buyer. That's more and more true depending on the degree to which your buyer will participate in the business. Your seller will participate in the business of the buyer. So you're selling, and your seller is going to be employed by the buyer. Well, if your seller is employed by the buyer for some long-term period, or the buyer is relying on the seller to grow a certain division of their business, they're going to want that seller to have an iron in the fire. They want that seller to know if they don't do well, they're going to lose a pretty nice chunk of their purchase price. If they do well, however, it's going to multiply the size of their purchase price. So depending on your particular situation, whether or not your seller is going to stay in that business, that rollover equity, which means equity purchased as part of your purchase price in the buyer, will vary. And you can get a very good idea of what everyone's intention is depending on how much rollover equity is required. People that just want the business, they'll plug in their people. They don't really care about the individual seller. They're more than happy to pay cash. If they really are buying the expertise of the seller, they won't.
And just a practical tip is if you are the seller and you're presented with a financial package where there's going to be a large amount of the purchase price tied up in rollover equity, you'll want to ask to see the financials and the governing documents of the entity that you're rolling into relatively early in the process, just so you can get comfortable with it. And if to do your own financial analysis.
That's a great
professional
point.
side.
Actually, we find that we're one of the only firms that actually asks for financial information on the buyer, because they're so surprised that we're actually requesting background financials on this investment that the seller is going to make in the buyer. They're so I guess proud to be buying all these companies, and they're kind of in charge, and they're passing out cash and equity, that they're kind of taken back sometimes that we ask, well, what exactly, is our seller buying?
Right.
And so there's actually due diligence on the rollover side that should not be missed.
And then one other practical tip is on we talked about the H10 election earlier, the election to treat assets or stock sale as asset sale for tax purposes. And I find that having a discussion about that early on is better, because you don't want any surprises when you're knee deep in the purchase agreement. And when there's a tax benefit to the buyer, there's going to be a tax detriment to the seller, and you'll want to at least float the idea of a gross up or some way to compensate the seller for the potential additional tax consequences of the election.
Yeah, the election basically, what it allows for is the re-rack of depreciation on the assets purchased. So if for some reason that the buyer intends to buy the box, the entity, and drop the entity under its holding company, that's fine. But what they want is a tax basis where you take the full purchase price and it's applied to the assets of the selling entity, so that they don't buy the box, and inside the box are the assets which have been fully depreciated, so that there can be no further depreciation. And if there's a sale, there's actually recapture of income tax, which is a very negative tax situation. If you buy the box and you don't make the election, you take those low basis assets.
The next section of our discussion is due diligence, and I find that this is probably the most labor-intensive, arduous process for the client, or their administrative staff, because they're having to go through records and documents and pull historical data to satisfy due diligence checklists that are prepared by the buyer. And they could be several pages in length and a lot of different items. So generally, when we're asked to do legal due diligence, we're looking at the governing documents to confirm organizational structure of the target, who owns it, who has the ability to sign, whether there's any liens or encumbrances on either the equity or the assets that are held by the target entity. There's also accounting, financial due diligence, and this is the point in time where the buyer will hire their own accounting firm to verify the financial statements and EBITDA to make sure that they're paying the appropriate amount for the company.
In light of the higher prices we're seeing some waning of that. But in light of the higher prices, the private equity groups have really turned due diligence into kind of a different process. I mean, we've been doing these deals for about 24 years, and accounting due diligence has always been significant, because you have to figure out, you're buying what you think you're buying. The books are in order, et cetera. It's like an audit, basically. But because these private equity groups are paying, let's say, instead of a 5 times multiple, they'll pay an 8 times multiple of earnings, due diligence is very arduous. It used to be maybe 30 days. Now it's at least 60 or 90 days. They typically have a particular large firm that you have to use for this. You have to generally segregate a room in the business, or you have to do this uploaded data room, which is very detailed. It's just a heads up when you get into these private equity deals. The due diligence part of the deal is much more arduous than historically speaking.
There's also human resources and risk management, and this is typically done, by the buyer, and they'll have internal people do background checks and check out insurance loss histories. Just a heads up that if the principals are going to be involved on a going forward basis, they're going to be working for the buyer, this aspect of due diligence could involve really comprehensive background checks. And for those of you who are representing sellers, you may want to give your clients a heads up that it could be a little intrusive depending on how particular the buyer is going to be.
That's right. We had recently an event where we represented a group, and the detail that came back on someone's divorce and activities years and years ago was outrageous. It created actually a rift for a few days in the deal because it was so intrusive. So that's a great idea, Kathryn, just to kind of prep them, and even to the extent that if there's something out there that they think may exist, maybe we should get a heads up on that to let the buyer know, just to kind of tamper the impact of some of these background checks.
In the situation, it just came as really out of nowhere, and it was a difficult, situation for our client, just from the emotional and the mental standpoint. And everything turned out fine. It was just something that I think could have been headed off if it was handled properly. Regulatory due diligence. Here, I just want to point out, in very, very large transactions, you may need to file some pre-closing notification paperwork with the FTC or the Department of Justice. That's under the Hart-Scott-Rodino Act, and there are some mechanical tests that you would look at to see if you'd have to file.
There's some safe harbors.
Right. And so these tests here, those numbers, 84.4 million and 16.9 million, those are adjusted annually. So if you have a very large transaction, you'll have to look at what the applicable thresholds are financially. But the size of transaction test measures the assets and equity acquired or to be acquired, and the size of person test measures the net sales or worldwide assets of the parties, the buyer and the seller.
So if you fall under these threshold tests, you don't have to worry about that Hart-Scott. It adds another whole layer to the transaction.
Here in operational due diligence, this is where I think we have a lot of the clients get fatigued in that they're having to pull leases and employee agreements and all these different contracts applicable to their day-to-day operations. And so as a seller's counsel, we typically try to limit the scope of what has to be produced. Often you'll see in a due diligence request, a request for all material contracts pertinent to the business. Well, we'd like to know what exactly is intended, and if it's possible to set a dollar amount or some kind of other materiality threshold to help reduce the buyer's or the seller's disclosure burden, we try to do that. Buyers sometimes are accepting of that, sometimes they're not, but it's at least a good conversation to have.
You can't have a deal tied up on a coffee.
Right, exactly. Unless we're a coffee company then.
Yeah, right.
Here is kind of the meat and potatoes, if we're going to go back to our meal analogy here, of the transaction, which is a definitive purchase agreement. And you'll see that the bulk of our outline is focused on this area. It is the central document that's going to govern the entire transaction. And later we'll talk about some ancillary documents. But here we're going to go through some of the different categories of topics that are typically addressed in the purchase agreement. First, obviously, and most important to the client is the purchase price and payment terms. Again, you're going to want clarity first in what is paid up front, and then also if there is a contingent earn-out or some kind of consideration based on future performance of the company after it's in the buyer's hands. You want to establish clearly those earn-out targets and milestones, and including the earn-out period, how payments are going to be made, and the mechanics for measuring the target company's performance, and also resolving disputes. And here's a slide on the H10 election if you'd like to take a look at more detail as to the benefits and the detriments to the seller and the buyer. Again, what we try to do to protect the seller is either negotiate a gross up, meaning there's an increase in the purchase price to the seller to help offset the extra tax that the seller would be paying as a result of the election, or including an indemnification provision in the agreement that would require the buyer to reimburse the seller for the increased tax costs. Another aspect that is documented in the purchase agreement is working capitals and true-ups. So during due diligence, the due diligence team will figure out how much working capital is needed to run the business. This is one of our clients for a month. It's the gas in the tank
Yes.
to
food on the plate.
right, to run the company. And so there's typically a few days before closing, the seller will deliver to the buyer an estimated working capital statement, and then there could be an adjustment either at closing or after closing, or both in some cases, to true up to the actual financials. And so the purchase agreement will typically set forth the deadlines for producing working capital statements, for instance. It'll set a date after closing to do the true up, and then also you would want to have a dispute resolution process and a review process so the parties can try to amicably, resolve any positions that they're taking different sides on the working capital. We've seen it where if the parties can't resolve it internally, they will hire an independent CPA firm to make a determination, and it's better to have the CPA firm selected in advance, if at all possible.
Yeah, if you can map out that whole process in the definitive document, everything's much easier.
Right.
So what happens is a financial statement is produced a month after closing, and that financial statement says we pegged working capital when we signed the agreement at $100,000, and lucky for you, it came in at $110,000. So now we will pay you back the extra $10,000 of cash, or the opposite. The number came in at $90,000. You owe us $10,000, and we're going to take it off the promissory note, or you've got to pay us back cash, etc. You can imagine, the disputes possible with this, and how it's calculated, and what's working capital, etc. So the idea is to say, okay, we're going to have Cowboy CPA, determine the Cowboy number 35 days after closing, and everyone agrees that this CPA is okay, and whatever he says goes, and that kind of eliminates that whole problem. It's kind of a complicated couple of pages, believe it or not, it's working capital. And if you don't do that, and in a few deals, the other side is kind of shied away from it. We try not to shy away from it. If you don't write it all down like that, it can be a source of litigation.
And to take off on that, there's also, within the purchase agreement, you can define, what current assets and current liabilities are for purposes of working capital calculation. So if you have a business that, typically it's cash and then also accounts receivable, where if you have a business with a large AR and a pretty good collection history, you may not need to leave as much cash in there. So there are ways to tailor that within your specific transaction to fit what the client needs. And again, purchase price allocation, this is another thing that we like to agree upon prior to closing if possible. The more you can agree upon up front, the better. We have had a transaction recently closed where the buyer was not in a position to do that, and they had to do it after closing. And if it can't be agreed to in advance, again, you want to build in and review a dispute process to make sure that goes smoothly.
Why don't we explain when we would have a purchase price allocation and what the screening would be about?
Okay. Well, you'd have it in an asset sale, for instance. There's different categories of assets, or if you'd make it an election of deemed asset sale. And so the parties can allocate purchase price among several classes of assets, like intangibles, and then you've got depreciable assets. And so really there's a little bit of jockeying as to how to allocate the purchase price, depending on whether you want to benefit the buyer or the seller.
Yeah, so if depreciable assets take on a lot of the purchase price. So let's say it's like a copier machine company, and they can depreciate a lot of these copier machines. Well, the buyer is going to say, I want to move as much of the purchase price to the copier machines as possible. The problem is that the seller has already depreciated the copy machines. So if we move purchase price to the copy machines, the seller has to pay recapture of depreciation, but the buyer gets the increase in tax basis. So that's the scream out. You usually work at a happy medium, but Kathryn's absolutely right. You have to allocate everything up front because they're never going to agree to this after the fact, never cleanly going to agree. There's also a tax form where you file your allocation, and an easy way, because the CPAs love the tax forms, to handle it procedurally is to just attach the agreed tax form to the back of the document as a schedule.
Okay, seller reps and warranties. Now, this is the area that could potentially create the largest exposure for the seller because they're essentially being asked to give the business a clean bill of health, and so they do that by making reps and warranties in the document as to the status of certain items like litigation, having regulatory approval and consent to operate the business, etc. So typically you can categorize these reps and warranties into fundamental and non-fundamental representations and warranties. The fundamental reps we've listed here in the slide are typically things that go to the heart of the deal, like the legal ability of the parties to enter into and consummate the transaction, the legal existence of the target, how the target is capitalized, and also the financial ability of the buyer to consummate the purchase. Also, tax and ERISA compliance are typically asked. The buyer will typically want to include these. As seller's counsel, we want to limit kind of the scope of the fundamental reps as much as we can, but tax and ERISA compliance are typically areas the buyer wants to see.
So these just to be basic. If you are not truthful about these fundamental things, you've got to pay the buyer back. Right. And the jockeying that goes on is basically the degree of the representation. So it's either a crisp representation, black and white. In other words, I have no tax issues. There is no tax issue associated with the business. If something comes up related to the business as it stands, and it relates to an event that's prior to closing or was caused by something prior to closing, then the seller has to pay the buyer back. But what we want to move toward, for instance, if you're representing the seller, is, well, I'll represent to you that it's true, but only if I knew it was true, for instance. So you've got the negotiation is, well, I don't want to represent the things I don't have any way of knowing about. But what the buyer says is, we don't really care if you know about it or not. We are not taking on that liability. You are. So that's kind of the back and forth that lawyers love to entwine themselves in.
And the connection between the reps and warranties and indemnification, which we'll talk about later, is if there's a breach of a rep and warranty, then it could trigger an indemnification obligation. And we'll talk later about how to kind of contain that from the seller's perspective. Disclosure schedules, again, if I had to make a list of top 10 things that irked my seller clients, it would be disclosure schedules, because they're having to go and it's tedious to gather all the information. The reason you have the disclosure schedules is if there is something about the representation that's not true, you're going to have to disclose that. So here in our example, a crisp disclosure, a crisp rep would be no litigation pending or threatened.
Right.
If there is something out there, you would say, except as set forth in this disclosure schedule, and in the schedule you would describe what the issue is. There is no litigation pending or threatened. So that, again, is a way to document that the seller has, in fact, disclosed the issue.
And so, yeah, so you want, if you're the seller, you want to be as broad as you can. I mean, you want to make sure it's fully disclosed so no one can come back and say, you didn't tell us that. And then the other issue, which we've had a lot of discussions on over the years, is, okay, you're buying the business, but I want to sell it as from the seller's perspective, kind of as is. So I know that I have this issue. If I tell you about it, am I still responsible? Because the style now is, it doesn't matter what you tell us, you're responsible.
And we'll talk about that later. We'll talk about this concept of sandbagging when we discuss the indemnification provisions, and you'd be surprised, but there's a lot of variation in state law as to what the resolution of that issue is. Yeah, it's interesting. It's, you know, there's arguments on both sides, but from the seller's perspective, you'd want to be able to take the position that I disclosed that you knew about it, you closed anyway, and therefore it's safe.
And language is added though by buyers a lot that says the opposite.
Right. So materiality and knowledge qualifiers, these are ways to kind of hedge on those reps and warranties. Gary had mentioned knowledge. We don't want to have to represent anything that is not within our knowledge. There's ways to define knowledge. As the seller, you're going to want to define it very narrowly to the actual knowledge of certain people without any requirement to make inquiry at all. The buyer is going to want, obviously, to take the opposite approach. Either it's an unqualified rep, or they will want to expand the definition of seller's knowledge to include constructive knowledge, things that you didn't know but should have known after a reasonable inquiry. And also, instead of listing specific individuals, to list classes of people like directors, officers, management personnel. So again, that's part of the negotiation, is how to define knowledge. Another qualifier is materiality. Rather than saying I'm in complete compliance, it's material compliance or compliance in all material respects. That again gives a little bit of wiggle room in case there's some kind of small issue that is not material to the business or the deal. Oftentimes we'll see buyers counsel wants to do this thing called a materiality scrape, and there's some sample language there for you, but it essentially allows when looking at indemnification to read out materiality as if it wasn't even there. So we have a lot of discussions about this with opposing counsel. Again, there's two sides to an argument. We obviously want to exclude the scrape, if at all possible, for our clients or sellers.
It's kind of hard to follow, too.
It is hard to follow.
I find it hard to follow.
Yeah.
Between the words scrape and read out, it gets a little conceptual.
Right.
Why is it there if we're scraping?
Exactly.
It's kind of odd.
The buyer also makes reps and warranties, although they're less, onerous than the seller in this type of deal. What we'd like to see as seller's counsel is a buyer rep that they have made their own independent investigation, and they're, we're trying to limit reliance really on the seller's reps. So we want to see something in there that says the buyer is a sophisticated buyer, they have the capability of evaluating the risks and the merits of the investment. And also we want to see securities representation, in the buyer rep section. Again, you've got a fundamental representation of the legal existence and authority. And also what's important is to confirm or to document whether or not a broker or an investment banker has been involved in the deal. Because you don't want a situation where there's an undisclosed broker and the sellers, in a position have to pay.
Definitely on the rep that they're aware of the purchase and how the business works, and that there's no expectation. We have given them no promise of profits or success in the business. That becomes very significant, because oftentimes when a business starts to lose money after the fact, it's from mismanagement and a new buyer, where they don't understand the business. It's particularly true with some of these hedge funds, these private equity hedge funds. Occasionally you'll have a group that's really new to this particular area of business, and when it fails, they're going to be looking for a lawsuit, for a cause of action in a lawsuit. And the fact of the matter is, if you've given representations based upon financials, they should be limited to the fact that those financials are accurate, because they are accurate. They're what their accountants, the seller's accountants, has prepared over the last 3 or 4 years. But that they can't be relied on to be reproduced in the next 4 or 5 years if you don't manage the business well. So the fact that the buyer represents no assurances as to profitability can be very significant.
In this slide, we describe some pre-closing transactions that are common when a seller is selling equity. And for instance, if there's accounts receivable or cash in excess of the working capital target, typically those would be distributed out, simply because those receivables and cash were earned under the seller's watch and at the seller's expense, so those should come out prior to close. Also, if there are any tax refunds associated with pre-closing tax periods, you want to document that those refunds go to the seller, because it could be years after the fact where the IRS gets around to issuing a refund, so you want to be clear that that is the seller's property. Pre-closing covenants are another important part of the purchase agreement, and these are needed if there's going to be a lag between signing the purchase agreement and the actual closing. And we'll get into reasons why there could be a lag later, but typically the purpose of the pre-closing covenants is to ensure that the business will continue to be run in the ordinary course and to maintain the status quo. So for example, the buyer is going to want a restriction on being able to, the seller being able to hire and fire key personnel or make distributions and dividends. So as a seller's counsel, you're going to want to make sure that the covenants are not so onerous that it would inhibit the seller from running his or her business, because there's always a possibility that the deal can't close or won't close, and you don't want the seller to be in a position where they've been boxed in and operating the business where it'd be hard for them to recover after a transaction falls through. And again, here's some of the conditions to closing. You got the covenants, or the things that the seller will or won't do, or the buyer will or won't do in advance of closing. And the conditions are the things that have to happen to obligate the parties to close. Sometimes if the buyer is seeking outside financing, which isn't really common in the private equity situation, but we've seen it in other scenarios, the buyer will want the right to walk away if their financing falls through. Typically, you'll see the attainment of third-party consent, either regulatory or lender or landlord consent to the deal if they're required under the transaction documents governing the loan release, for example. That'll be a condition of closing. And also, of course, that the assets are free and clear. The assets owned by the entity are free and clear or can be cleared up.
The consent has become a pretty big issue, especially with the healthcare transactions, because there's been so much activity. The regulatory agencies that consent to transfers of ownership, either assets or stock, are pretty backed up. So sometimes you want to get those consents rolling. We used to wait till we were midway through the transaction, but we suggest that a lot of these governmental type consents get started early on when you first start drafting the definitive purchase agreements, because it usually takes at least 60 days.
Correct. And this is really the hot area that the lawyers fight about in a deal. And really, if you kind of look at it from the big picture, in terms of the asset versus stock form of sale dichotomy, through the indemnity provisions, the buyer is going to want to shift liability back to the seller to make a stock deal functionally equivalent from the liability perspective to an asset deal. So the indemnification provisions in hand with the reps and warranties are really intended to do that. If you're the buyer, you want, even though you're taking on the box, you want to shift as much of the liability back to the seller as you can under the contract.
So to be like specific, because some people listening may do this all the time. Other people just want a flavor. What Kathryn's saying is, if you buy the box, right, the box is an active LLC or an active corporation that's owned by the individual owner, and the individual owner has the right to sell the box. But the reality is, in these agreements, the buyer is going to also want representations with respect to what's inside the box. So if you had an asset purchase, you'd be selling what's inside the box directly, and you'd have all these representations, and the indemnity would cover all of the status of every single asset. But even though you're buying the box, all those representations will come into play, and if they're breached, will trigger the indemnity.
So ways to limit the seller's liability, you can do it in a few ways. You can set monetary limits on what the seller will have to pay if there is, in fact, an indemnifiable claim. We'd like to see a cap on the overall liability. Obviously, the seller does not want to pay more than he's getting. Or
Yeah,
he's
that's
getting
a
for
good,
the
that's a
business.
good point, Catherine. That's a good place to start a lot, is we start like maybe with a cap to the extent of the consideration paid. Like, because although they may be buying this, and let's say even the buyer's putting in $100 million or something like that, so it'll be a much bigger operation within a short period of time. If they mismanage it, or it just goes badly and they somehow have a suit against the seller doesn't have to pay actual damages. The seller pays damages only to the extent of money it received, which triggers a lot of other planning, by the way. You know, then you get into all kinds of asset protection planning and what are we going to do with the proceeds and how does that work? That's a different seminar. but it raises that issue. If you're a seller and you're subject to one of these massive indemnity obligations, well, do you need to take title or do any planning? It's just something to keep in the back of your mind because it's become a huge issue, actually.
Right. So the cap sets the ceiling, and you can also set a basket, which is the floor, where the reason for the basket is you don't want your client to be, or your seller client to be bugged with, you know, a $500 claim here and there. It's a nuisance. And so you want to set a floor. You can do that in a couple of ways. One is like a deductible, where the buyer agrees in the purchase agreement that they're going to absorb the first, you know, $50,000 in losses, even if they were indemnifiable under the terms of the contract. A second approach is doing a tipping basket, where, you know, the first $50,000 the seller is not liable for, but if it crosses that threshold, then they're liable from $1. So those are just a couple of ways to limit the kind of the monetary exposure to the seller. Just a little nuance here is going back to the concept of fundamental versus non-fundamental representations and warranties. Typically, buyers don't want to see a cap or a basket on fundamental representations. Again, in their mind, it goes to the heart of the deal, so those shouldn't be subject to those kind of limitations. Another thing we've seen recently is this concept of representation of warranty insurance. And there's actually insurance companies that will write policies to insure these kind of risks under these purchase agreements. You know, and in doing some research, those are really, you know, they make the most sense in large transactions where I think that the enterprise value is $20 million or more. It can be expensive as far as getting the coverage, and then there's also a time factor in having to build in the timing to underwrite it. So
it's a very interesting concept. I mean, we've dealt with it several times now. It's kind of a customized policy in general, where oftentimes we can actually get the buyer to pay. I don't know why it's like this, but oftentimes the buyer's willing to pay for exposure to the seller, really, for breach of a warranty or representation. So these indemnity claims, some or all of them can sometimes in large transactions be absorbed by an insurance policy. I mean, we all know how insurance is. I mean, some of the investment bankers really love this, and we like it, but there are so, you know, there are pitfalls as well. It's expensive, but you know how insurance is. I mean, it's wonderful. Everybody's very nice and amicable when you're writing the insurance company a big check, but when it comes time to actually pay out on these things, it's a completely different, you know, negotiation.
Right. So, you know, again, going back to why would the buyer pay for it, I've seen it where the buyer may be in a situation where there are multiple buyers and they want to differentiate themselves from the pack, and so they'll offer that in the LOI. They'll offer that to kind of sweeten the deal to get a leg up on competitive buyers. Another way to limit the seller's indemnity exposure is to shorten survival periods. For example, you know, reps and warranties only last for a year after closing. That way, if a claim comes up and it's, you know, a year plus a day, you have an argument that that's not covered anymore. Again, the shorter is better for the seller. We'd like to see a year or less. Sometimes, you know, with certain kinds of reps and warranties, such as tax reps, regulatory reps, it'll be the statute of limitations period plus 60 days. But generally shorter is preferred from the seller's perspective. On fundamental representations, the buyer often will want to see an indefinite survival period, which practically it survives until the underlying statute of limitations expires.
Yeah, what Kathryn means by the statute of limitations is that if in fact seller incurred a liability, there's a time period, a limited amount of time during which the claimant, who would have a claim on the business that's being purchased, has to file suit. So if basically what the buyer wants is to buy the business and that the seller owes a indemnity back to the buyer if there's any exposures to lawsuits, and they don't want this indemnity to go away or these representations to go away until that underlying claimant no longer may file suit.
And then down at the bottom of the slide, we've got a couple other ways. Indemnity is your exclusive remedy, meaning, you know, if the seller is agreeing to be exposed to an indemnification claim, that's it. They can't really, the buyer then can't, you know, resort to other remedies that may be otherwise applicable under general contract law or state law to be made whole. The double recovery means if there's insurance or something out there, a third-party payor that would cover the claim, so they said that they're receiving recovery from another source, the seller should not be held liable. And of course, fraud, you know, all bets are off typically if there's fraud involved. The caps don't apply, the baskets don't apply, all that stuff doesn't apply. Okay, here's the sandbagging thing we talked about earlier, and we've included some sample language. This language here is pro-seller, meaning the seller is not liable for any losses if the issue, you know, the inaccuracy or the breach was disclosed prior to closing. And here the purpose is just really to provide the seller an affirmative defense against an indemnification or breach of warranty claim. Buyers will typically want the opposite, where their language will say, notwithstanding any investigation or due diligence review, if we close, we can still, you know, hold you to the reps and warranties. And so there's a lot of tension, or there has been in some recent deals that I've done, where we're going to have opposite perspectives. And so a compromise could be just to leave it out completely. Don't mention it all in the document. If that's the case, then you're going to want to make sure that you check under the governing law that's agreed upon on the agreement is to govern the transaction, what that state's law is going to, how it's going to resolve if there's no express provision in the contract. In Delaware, for example, which is kind of the leader, I guess, of corporate and M&A law, absent an express anti-sandbagging provision, the trend in Delaware courts is to permit the buyer to prevail on a claim for a breach despite having pre-closing knowledge of the inaccuracy or the misrepresentation. So Delaware is, you know, pro-business, and that it makes sense given kind of their postures in corporate law. California has a different perspective, and they're a little bit more liberal in that they tend to take the opposite position. For Florida, I did some research this morning, and we haven't found a Florida state law case that addresses the issue, but there is a federal case out of the Middle District of Florida, I think it was in 2004, where that court predicted that if this was presented to a Florida court, it actually kind of aligned more with Delaware, and that a disclosure prior to closing wouldn't have the effect of waiving the buyer's claim for breach. So that case is Southern Broadcasting versus Gembroad. If anyone is interested, and is the site is 1451 Federal Supplement 2nd 1316. And that case, it gives you a good background of kind of the split of authority on the issue, and also a good articulation of what a Florida court would likely do presented with the issue.
Yeah, and we don't recommend leaving it blank. It's just a negotiation issue. You know, a related issue that is often missed on the M&A side is when you do the indemnity, you have to write in, especially if you're representing the seller, that the indemnity is the extent of the claim. There's no more claims, because if you don't write in that this indemnity is the only thing that the buyer can claim damages on, it's kind of unlimited. They can make any other claim up that's not in the document. It's happened a few times, so you have to be careful with that. we're working on 12:50 now,
Yeah,
so I didn't know. It's
kinda
usually
glossed.
a 50-minute seminar, and we have an ability for you to type in questions
Right.
on the go to meeting what is it called, go to meeting.
Mm-hmm.
We don't have any questions. If you have questions, feel free to type them in. Of course, after the seminar, at the end here, we'll give our email addresses, and we can send anyone a copy of the whole
Mm-hmm.
slideshow, at your convenience. I guess we'll go another 5 minutes and wait for some questions, and then our narrator will come up.
Okay. So here we talked a little bit about earlier about escrows and holdbacks, and a common reason to have an escrow is to fund indemnity claims if there's one down the road. So you're going to want to negotiate out the term. Shorter is better after closing. You don't want the buyer to be able to hold on to it for a ridiculous amount of time. And if a third-party escrow agent is used, they're going to typically they'll have an escrow agreement that you're going to have to review and negotiate as part of the closing. The pre-closing documentation.
It's also going to create a lot of expense.
Right.
And if that escrow is actually called upon to cover an indemnity, you thought that the expense was high just to use the agent. I mean, the agent then lawyers up, has to deal with any litigation, and you end up having to pay out of escrow proceeds directly. All this costs associated with that involvement of the escrow agent. You have to keep that in mind because it can be very substantial.
One other aspect of this, typically addressed in the purchase agreement, is how to terminate. And this isn't needed if you sign and close simultaneously, but if there's going to be a lag, there should be termination language in there that would allow either party to terminate, assuming that the conditions of termination are met. So we just kind of outline here what's typically seen in termination provisions. Timing, again, the closing could occur simultaneously with the signing of the purchase agreement, or there could be a lag. If there is a simultaneous sign and close, you don't need certain things like the pre-closing covenants, the conditions, and termination rights. The reason for the need for a delay could be getting regulatory approval or some other contingency that has to be met before closing. And here we list out some of the closing documents. We've got LLC consent. One important aspect is the employment agreement or the consulting agreement that's going to bind the principal after closing. You're going to want to make sure that the comp is what the principal wants, and also any restrictions on competition or reasonable.
Yeah, exactly. When can this seller go back into this industry, if ever?
Right. And here's a list of transfer documents, and again, we talk about the escrow agreement. One thing that I didn't mention in the outline, but I want to mention in the discussion is, if your client is a seller and they're selling a partial interest in their business, the buyer is going to want to likely substantially overhaul the operating agreement to protect the investment. So you'll be negotiating the operating agreement for the target, likely as part of the negotiation of the deal. We got the question and answer session?
Yeah.
Okay. So we'll skip ahead to the Q&A. If anybody has any questions, that's you? Okay.
Yeah.
Feel free to go ahead and
put us back.
I'll put us back. Okay.
We're real people, see? Well, we don't have any questions, so I guess we'll wrap it up. Our email's there. If you want a copy of the seminar, just let us know. And that will conclude our session for today. We appreciate your attendance. And we look forward to seeing you next month, or at least talking to you next month, at 2 new seminars we'll do. One will likely be on the foreign trust, the other on healthcare.